question here is, does the landlord that purchases a property from a seller with an existing tenancy assume the lease under the law? Hi, my name is Rob Wells. I'm the Landlord War on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, this commenter here was basically stating, hey, sorry, if I don't have a lease agreement with a tenant where I just purchased the property, they're out of luck. And unfortunately for this poster, and the misconception from a lot of new landlords that purchase properties with tenants in possession, there's a large body of law, including Civil Code Section 821, that basically states that, hey, when a property is sold with an existing tenancy with it and there's an agreement, the successor landlord basically gets to step in the shoes of the landlord, okay, that entered into the agreement. There's several points in the law of this, including a bunch of case law. There's Civil Code Section 827, and then there's Code of Civil Procedure 1161, and the Code of Civil Procedure also references like successor and interest, that type of deal that allows a landlord that purchases a property with a tenant in possession to basically enforce the terms of the lease that the prior seller had basically with the lease agreement. Okay, without getting into the weeds and having a 10-minute video on this, landlords that purchase property, or buyers that purchase property with tenants, whether they know about it or with constructive notice, that type of deal, you get possession of the property with those tenants. Okay, and that's how that works. Okay, and the law allows you to enforce the terms of any written rental agreement as the successor of the property, because you are the real party in interest and legal lease. You're the person that owns the property now, so you get the incidental rights of the lease and ownership and so forth. So you can go to court and you don't have to have the lease in your name, although a lot of landlords and tenants do enter into agreements with their names on it. That's not required under the law because of the common law basically, and the rules in the Civil Code and the Code of Civil Procedure. So as a friendly reminder for anyone succeeding an owner, you have to give a change of ownership, management, and service of agents a process notice pursuant to Civil Code Section 1962. We've talked about that on the channel, so just make sure you do that within 15 days of becoming the new owner of the property, and you basically assume all the rights and so forth of the lease agreement, unless there was an agreement to the contrary, such as the purchase agreement or deed reserved. The prior owner had rights to enforce the lease. So that's the general rule. And landlords, if you are just purchased a property and you're having problems with tenants now and you need to know your rights and so forth, and you're in the Northern California area, feel free to reach out. We might be able to help out. Put your comments, questions down below. Try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.